thank everyone for joining our special webinar discussion of the Supreme Court's Montanile decision today. We'll just start with some introductory stuff while people are still joining the conference. If you've got questions, I'll try to get to them at the end. And there is a question bar that you can submit questions in the GoToWebinar drop-down menu. It should just be right on your right. If you've got any questions, they'll show up there. I will try to get to those at the end. Other than that, we've got a pretty broad audience of attendees here that kind of covers the entire reach of the insurance industry. So I'll try to hit on as many of the broad-reaching effects as I can think of today. Again, if you've got questions, submit them throughout the webinar. I'll get to them at the end. We've only scheduled for 30 minutes, so I kind of want to get moving and cover the ground that we need to get covered. The facts of the case, the Montanile decision, are pretty typical of what we see every day with health subrogation. In December of 2008, Mr. Montanile was injured in a car accident involving a drunk driver, and his health plan paid a little bit over $121,000 to cover the cost of his medical expenses, which included, I think, a lumbar fusion, so that's why they were pretty significant. In addition to a standard subrogation provision, Montanile also signed a separate subrogation agreement, basically agreeing to reimburse the plan out of any recovery he would later make. Montanile later retained a personal injury attorney, and a third-party claim was filed against the at-fault drunk driver. In addition, underinsured motorist claim was filed against his own insurer. He ultimately ended up obtaining a $500,000 settlement. The numbers of that settlement are kind of on the PowerPoint. You can see that $200,000 went to the attorney's fees. Montanile got an advance of $60,000, so he had to repay that. He ultimately netted $240,000, so about twice what he owed back to the plan. The plan and his attorneys were attempting to negotiate the lien for several months. In fact, the parties attempted to, I think, negotiate from June of 2011 through January of 2012. After those negotiations broke down, Montanile's attorney advised the plan, basically in a letter, that it would be dispersing the funds in 14 days unless the plan objected. It was not until July of 2012 then, so about 6 months later, that the plan ultimately filed suit in federal court under 502A3 of ERISA, seeking to enforce the reimbursement provision of the plan. So what did the lower courts do? Well, actually the main issue in the case at the lower courts, that'd be the Southern District of Florida and then the 11th Circuit Court of Appeals, was whether the subrogation provision in the summary plan description was enforceable. The plan in this case, operated only with an SPD and did not have a separate master plan document. The lower courts both held that the SPD was the operative document and that the subrogation provision was enforceable. That particular holding was not appealed and remains good law within the 11th Circuit. Now, the issue that the Supreme Court did grant cert on had to do with whether the plan's equitable lien could be enforced against Montanile's general assets, to the extent he argued that he dissipated the most of the settlement funds on non-traceable items during that 6 months between the time his attorney dispersed the monies to him and the time that the plan filed suit. Relying on language from Sereboff, however, the lower courts both held that there was no specific tracing requirement needed for equitable liens by agreement, and that they could be enforced upon the participant's general assets. So that's a great decision for the plan, and we were all pretty excited about it. However, after the 11th Circuit issued its opinion in favor of the plan, Supreme Court counsel took over both Montanile's case and the Airtran versus Elam case, which a number of you are familiar with. Both of those cases were decided around the same time by the 11th Circuit Court of Appeals, and they both had dissipation issues in them. He appealed to the Supreme Court on the dissipation issue in both cases, but later decided that Montanile had the better facts, so he was going to focus on that case. Remember, for those of you familiar with the Airtran case, that's the case where the attorney basically attempted to defraud the plan by lying about the amount of the settlement and trying to hide $475,000 of the $500,000 settlement. So that was not particularly a great case factually to get to the Supreme Court, and Montanile presented, I guess, a better vehicle to present the dissipation issue. The Supreme Court granted cert on that issue, and last week issued its decision. I don't think last week's Supreme Court decision was much of a surprise to many of us in the industry. To hold for the plan on the dissipation issue, the Supreme Court would have had to effectively overrule its prior decision in Great West versus Knutson. So instead, the court in Montanile reaffirmed its decision in Knutson that in order for a claim under ERISA Section 502A3 to be equitable, the defendants must be in possession of the funds at issue. The plan, however, had attempted to argue and grasp onto certain language in the Sereboff decision, which I'm sure you're familiar with, that appeared to create an exception to the rule for equitable liens by agreement. The argument, I guess, basically goes this way. The plan's equitable lien by agreement attaches to the settlement funds the moment they are identified, and any later dissipation cannot destroy the lien. However, the court disagreed with that reading of Sereboff. It held that equitable liens by agreement are enforceable only if the decree of the court can lay hold of that specific property. So essentially, where a participant dissipates the settlement fund on non-traceable items, the lien is completely destroyed. So what exactly is the good news? There's not exactly a lot of great news for us in this decision. However, we note that the court did not disturb any of its prior rulings. Pursuant to Sereboff, an equitable lien by agreement is still enforceable. And pursuant to McCutcheon, the plan's reimbursement rights cannot be defeated by equitable defenses like made whole or common fund, etc. So that's, I guess, limited good news. Second, not all dissipation is equal. An equitable lien will still attach to traceable items like cars, boats, stocks, bonds, and other tangible items. The Montanile decision only dealt with non-traceable items. So example, travel, services that cannot be traced. We'll talk about a couple other items that we've got to watch out for. But the Montanile decision is pretty limited to its facts. The third important thing that I saw in the Montanile decision for us is that commingling is not dissipation. So on pages 12 and 13, the court goes into a discussion of how historical equity would treat equitable liens by agreement. And the court discusses that commingling a specifically identified fund to which a lien attached with a different fund did not destroy the lien. In fact, commingling allowed the plaintiff, which would be the plan, to recover the amount of the lien from the entire pot of money. So what this means is that just because settlement funds are dispersed with a participant's general assets, they still remain fully traceable. And then finally, I guess the last nugget that was in this kind of good news is for those of you who defend breach of fiduciary duties against plans and their fiduciaries, the court throws in a minor victory in footnote 3. In that footnote, the court rejects the argument by the plan about the broad relief that should be available under 502A3. In doing so, it states that its discussion in Cigna versus Amara about 502A3 is purely dictum. So this has the potential to curb additional monetary awards in fiduciary litigation claims. But that's not particularly what probably most of you are looking at this for. So what new incentives are created by this decision? What can we see? What will start happening, I guess, now that the decision is in place? It's unquestioned to me that Montanile will encourage plan participants and their attorneys to disperse and dissipate settlement funds as quickly as possible to avoid any and all liability to the plan. You will see participants who will take their settlement funds and now spend them on what the court has called non-traceable items like travel, remodeling their homes, credit cards, student loan debt. All of that stuff is going to be really hard once it's spent to unravel. And it's going to be more difficult the smaller the settlements are. If a guy gets $20,000 in a settlement, it's going to be hard to trace that money if he goes to Las Vegas and spends it on a hotel and gambling and other items. So I think it's going to be a little bit of a problem in that respect. But my prediction of bad behavior shouldn't come as a surprise. I mean, this is exactly the behavior we already saw in cases like AirTran and the Central States versus Lewis cases that I've cited. In both of those cases, which were pre-Montanile cases, obviously, the lawyer for the participant engaged in unethical behavior and violated the terms of the plan by dispersing and dissipating the settlement funds. However, under Montanile's rationale, both of those attorneys would now be able to basically run scot-free from any liability of the plan. Finally, I think it's pretty obvious for those of you who do overpayment claims on behalf of pension or disability policies that the court's decision effectively forecloses all overpayment claims by ERISA disability and pension plans. In most every of those cases, the overpayments occur in small amounts over an extended period of time and are routinely spent on non-traceable items. So I think Montanile is going to put basically an end to that. What does this mean for health subrogation? Notably, the court rejected the plan's arguments that it is impractical and too expensive to monitor and participate in third-party claims and recovery opportunities. You'll find this on page 14 of the decision. Instead, the court noted that the plan had sufficient notice in the case and should have simply filed suit immediately when negotiations broke down. So my reading of Montanile is that Montanile squarely places the obligation to monitor and participate in litigation on the plans themselves. My math, which is, I'm not a mathematician, I'm a lawyer, so obviously I probably didn't excel in those math classes, but my math tells me that this means that either recovery costs for the plans are going to increase, or the plans will simply have to start dealing with limited recoveries. Because Montanile will require plans to engage in significantly more litigation, either through interventions or by promptly filing for injunctive relief under 502A3 when settlement negotiations break down. The current health recovery model, however, is not built for so much litigation. The costs of outside counsel are rarely baked into such service agreements. So is the old recovery model broken? Will Montanile essentially break the recovery model? While it might not break it, I think there are certainly some cracks beginning to show. The court's prior decisions in Sereboff and McCutcheon essentially made subrogation recovery easy and virtually automatic. Now, for any of you who are actually in that model, it wasn't exactly automatic, but it was so much easier than it was after the Great West and Knutson decision, but before the Sereboff decision, where it was very difficult. And for those of us who are in attorney positions, outside counsel positions, you'll remember we were running around the country filing TROs, seeking injunctive relief, trying to preserve funds so they were not be dissipated or dispersed. And I think we're going to be back in that position again. So, I mean, basically after Sereboff and McCutcheon made it real simple, you know, companies were able to easily monetize and capitalize on lien collection. And I think Montanile changes that model. The current recovery model is basically priced upon handling virtually all of the claims in-house without litigation and without having to retain outside counsel. However, Montanile is going to require diligence and participation in the litigation process. It requires having counsel who can file for injunctive relief essentially at the drop of a hat. No longer can we get away with thoughtful negotiations over the course of weeks or even sometimes months. Large settlements will begin to dissipate and small ones will already be gone. I think the trial lawyers bar, you know, my observation is really that they're a pretty smart bunch. I think they'll be all over this decision and its practical effects. I would expect that you can start seeing Montanile disbursement letters giving you 14 days to object before they disperse funds. They're going to copy that language right out of the decision and send it back to you in a letter saying, hey, this is what the lawyer did in Montanile, and it was okay with the Supreme Court. So expect those Montanile letters. You're going to start getting them. And essentially, when you get those, you're going to have to ask yourself, are you willing or able to file suit on these cases? I suspect many lawyers and participants will be willing to call your bluff. So either you will have to start increasing your legal budget to maintain your current rate of recoveries, or you will have to reduce your recovery opportunities. Because after all, time is not on our side. Either we accept a settlement or we run the risk of it being dissipated. What collateral damage can we expect? I know we've got a number of folks on here on the call from the property and casualty side. So how will Montanile affect settling and resolving of liability claims? I don't think Montanile changes any outstanding legal duties that liability insurers have regarding settlement. Certainly, ERISA does not place any duties on liability insurers to protect ERISA liens. However, I think you can expect that your plans and their representatives at least will begin peppering you with status requests as they attempt to comply with Montanile's diligence requirement. In addition, with the increase in litigation that I would be predicting, there's certainly an opportunity to envelop liabilities insurers and their insureds. You can expect an increase in the amount of direct state law subrogation lawsuits that are brought. I think you can also expect the increased 502A3 litigation will result in subpoenas seeking information from your insurer or your insureds regarding the traceability of those settlement funds. I think this will be especially true where there's structured settlements involved, seeking to unravel those. In certain cases where the litigation occurs promptly after settlement, I would expect that you could anticipate liability insurers being named as defendants in cases where they're still holding on to the settlement funds that have been identified. So yeah, I think it's going to be a little bit more of a burden to liability carriers. I don't think it's going to be anything earth-shattering when it comes to their obligations. But what about plaintiffs' attorneys and their liability? I guess I'd expect to see that, you know, obviously each plaintiff's attorney is probably going to review their own state ethical obligations about whether disputed liens need to be placed in trust pending resolution. Most states, but not all, follow the ABA's Model Ethical Rule 1.15, which requires that lawyers hold in trust any funds that are subject to a disputed claim, or arguably the property of others. Some states don't have that obligation. Georgia, most notably, is one of them. California lawyers seem to skirt around that obligation frequently as well. But setting that aside, I would expect that this is going to require plaintiffs' lawyers to request and study the applicable plan documents to determine what consequences their clients will face if funds are dissipated. We'll get to a little bit, the next slide, what those consequences could be. But I think wherever there are cases where a lawyer knowingly disperses funds to the client, they can expect to be named as a defendant in any 502A3 action, assuming it's allowed in that jurisdiction. The Ninth and the Eighth Circuits are somewhat questionable on that question. But again, I think wherever funds have arguably been dissipated by the participant, it may be easier for the plans to simply look to the plaintiff's attorney and go after the fee that he or she took, rather than tracing the individual participant settlements down the road. So finally, mitigating the effects of Montanile. I last want to kind of address what you can do as a health plan to start mitigating the effects of the decision. Well, first remember that Sereboff and McCutcheon remain good law. You have a protected lien, it's enforceable, and it can't be eroded by state law rules like made whole, common fund, or other lien reduction schemes. You're going to have to really start leveraging your duty to cooperate in the plan documents and red flag those claims where you are being ignored by the participant or the participant's lawyer for additional monitoring. And that additional monitoring is going to include potentially you having to monitor the online court dockets, or go down in person, have a runner go down in person and pull those dockets where they're not available in electronic format. Considering, well, you know, those, I guess, are in-house things that you can do, in addition to making sure that you're keeping in touch with the liability adjuster or the defense counsel assigned to the case. From an in-house perspective, you need to get and look at your plan language. Make sure that you have the best plan language. Make sure that you exclude benefits where another party is liable, but then in that same provision, allow that they will be advanced subject to the provisions of the reimbursement provision. Offset any future benefits owed to the participant or their beneficiaries where benefits have not been reimbursed. So if they're still on the plan and active, you have a big hammer to hit them with if they decide to run away with the money, essentially saying, fine, we won't be honoring any future claims up into the amount that you dissipated. Also, if the funds have been fully dissipated and the member is no longer on the plan, you can look into whether you can reverse the charges with the providers under an applicable network provider agreement. In those cases, you know, they're more difficult, but I've definitely seen it done, and providers pursuant to those network provider agreements have had to reimburse plans for those funds. Also, from a litigation perspective, I think we need to be considering intervention where possible. In states like Wisconsin and Ohio, where the plan is joined as a subrogated party, make sure you are retaining counsel and participating in those lawsuits. Your phone or email agreements with the plaintiff's lawyer saying he's not going to default the plan or he will contact you at the time of settlement are pretty much worthless after Montanile. Essentially, the inquiry is going to be about, you know, timeliness and dissipation, and not upon whether anyone agreed to protect your lien or not. Montanile also says you're going to have to file and be prepared to file 502A actions in federal court immediately when negotiations break down. The court, 6 months was not good enough. So all I can tell you is you need to be prepared to do that immediately once you sense that the case is settled and the negotiations have stalled. Finally, as a last resort, I think where funds have been dissipated, but the claim, the underlying claim remains within the applicable tort statute of limitations, you can consider filing a state law subrogation claim against the at-fault party. I do this maybe more frequently now than in the last few years, but by filing a state law subrogation claim against the at-fault party, assuming that you've got the plan language that allows you to do that, you will trigger the applicable release and the indemnity agreement between the participant and the at-fault party, forcing the participant to step in and indemnify the tortfeasor. That claim won't be limited to ERISA's equitable rules, and dissipation of settlement funds won't matter. So now I'm going to I think that's my 30-minute take on the Montanile decision. Let's see if I've got some questions. I'd be happy to turn to those. Let's see. The first one I've got is most of the plans we administer are ERISA plans, but several are self-funded, non-ERISA plans, public entities. Does Montanile affect those plans the same way it affects ERISA plans? The answer, I think, is pretty clear. No, self-funded but non-ERISA plans are not restrained by the equitable language in the ERISA statute. So the upside is that you can still sue a participant for reimbursement even after those funds have been dissipated. But of course, the downside is that you're going to be stuck with, you don't get the benefit of ERISA preemption, and you might be stuck with state anti-subrogation laws. Another question. Does an ERISA plan have the same super lien subrogation rights as Medicare? The answer to that is no. The ERISA lien rights and Medicare lien rights are very different, and it would probably take me another at least 30 minutes to get into that. But no, Medicare is not going to be bound by whether funds have been dispersed or dissipated, because their lien rights are not limited to equitable relief. So that's going to be a big difference between those two. Let's see. What about state bar ethical obligations to release settlement funds prior to settling, or not to release settlement funds prior to settling liens? And that's a good question. I kind of hit on that earlier. There are state ethical obligations. Unfortunately, those state ethical obligations are not enforceable in the civil context. So I can't base my lawsuit or legal claim against an attorney or a participant on ethical obligations. The best I could do is tell you you can file a letter with the State Bar Association complaining that the attorney dispersed those funds. Unfortunately, that's not going to be worth much, and it's not going to get your money back. What would be the best time to file a complaint in intervention? Well, that's a good question. I mean, technically, the rules allow a complaint in intervention to be filed at any point up to the point of judgment. But one of the factors is going to be timeliness, and so that's going to be a factor that's going to depend on the discretion of each judge that's seeing the intervention. I was mentioning earlier that in Wisconsin and Ohio, we get joined as parties to the litigation right immediately. So immediately we become parties. Our obligations are not the same necessarily, and we don't have to prove necessarily all of the underlying liability. We can kind of rely on the individual participant to do that. So we're not necessarily driving the bus throughout the entire litigation, but the earlier the better. Other states, I know New Mexico has has a rule where they prefer that you intervene after the settlement, but after the trial regarding any issues regarding subrogation. So you might have more leeway as a matter of time when you can intervene on. Let's see, I've got some more questions here. If we do flag cases where attorneys are not responsive, how should we proceed? Should we forward the case to counsel? I mean, certainly that's going to be a decision that you've got to make between the plan and any subrogation vendor that's handling it, the plan administrator. They're going to have to decide whether it's worth it to forward to counsel or not. I think there's a few steps you can take before you have to forward it to counsel. There are a lot of states have online court dockets you could check. You can also make sure you get with the liability adjuster and find out where things are headed. But certainly, if you have any sense that a settlement has occurred, you've got to get that to counsel and be prepared to litigate that case, because Montanile clearly indicates that we can't wait. We simply can't sit on it and wait for months before we file suit. My question is, if there is a chance this decision will be appealed, or if it already has been, it's so difficult to wrap my head around the fact that the court has essentially given people a license to steal. Well, thank you for taking a play off the title to the webinar. But no, this is the U.S. Supreme Court, so this is a final decision. There's no chance it'll be overturned. There's no chance that, I mean, I shouldn't say no chance. There's virtually no chance the U.S. Congress will modify ERISA to make any changes to it. So I would say we're going to have to live with this. And while it certainly does provide incentives for participants to take the funds or take the money and run, you know, we still have options available to us to mitigate from that happening. And, you know, the sooner we get involved with litigation, the less chance I think that will happen. Is there a copy of the PowerPoint available? I think we can circulate one at the end of this in an email to you if you'd like it. That's no problem. If you want to just shoot me an email, I will be happy to email you a copy of the webinar. I think that's all the questions I've got. Unless there's any more quick ones that pop up here. I appreciate all your time, everyone, for attending. Feel free to follow up with me personally by email or by phone if you've got any questions about specific cases, or generally how to set up maybe a new recovery model to keep this Montanile decision in mind. But again, thanks everyone. Enjoy the rest of your day.